When invited to speak at the Howard Library conference on the topic of refugee crisis or playing the populist card, I accepted with alacrity. The invitation offered an intriguing opportunity in the presence of the former Prime Minister to speak about the legacy of the Howard government's handling of the Tampa. As always, we are in the middle of several ongoing refugee crises. Some are recent, like the Ukrainian war refugee exodus, and some are protracted, as is the case with Palestinian and Afghan refugee populations. Some refugees meet the international definition of a refugee set out in the 1951 Convention relating to the status of refugees, while others, such as war or conflict refugees, may or may not meet the 51 Convention definition. When we watch the scenes unfolding in Ukraine, as we can in the modern era, we feel the pain of those leaving their homeland, pushed out by an unprovoked armed attack. They are in crisis, but if they were to arrive here without a visa and ask for our protection, does that mean we also have a crisis on our hands? The etymology of the word crisis is Greek, and intriguingly, the term crisis means decision. Back in August 2001, as the Norwegian freighter the Tampa headed for Australia with 433 asylum seekers rescued from a vessel in distress, the Australian government decided not to allow them to set foot on Australian soil. Rather, they were transferred to Nauru, and the so-called Pacific Solution was developed to ensure that any person seeking asylum, travelling by boat and without a visa, could be intercepted and sent to Nauru or Papua New Guinea. There, they were held in indefinite detention. During the Australian election that followed, Prime Minister Howard famously declared, "We decide who comes to this country and the circumstances in which they come." But do we decide the circumstances in which people come, and are we ignoring the circumstances in which they leave, along with the rules that we've agreed upon to govern this situation? It is evident that we in Australia or any other country of origin or refuge do not decide when Vladimir Putin invades or when other actors violate human rights or persecute someone on the basis of a characteristic like race or religion that they cannot or should not have to change. Along with the majority of the international community, Australia has agreed to cooperate with other countries by following a set of rules in the 1951 Convention and other human rights instruments to ensure that refugees are given protection. It is perfectly correct to say that in general, immigration is a process controlled by us. But these rules require that we do not simply assume that someone is not a refugee. We do not penalise someone simply for arriving without a visa. We recognise that refugees are human beings just like us, and we provide protection where necessary because refugees have lost the protection of their home country. Given that broader context, I think that phrase, "we decide," is a populist call to the people of the country, the we or the us, to say that we're still in control, and if we decide to, we'll ignore criticisms from outside and depart from our own long-standing practice. As Marion Saw has pointed out, given Mr Howard's previous speeches, such as the Headland speech of 1995, we are mainstream Australia. And mainstream Australia, according to the Headland speech, was frustrated by government decisions increasingly driven by the noisy, self-interested clamour of powerful vested interests with scant regard for the national interest. This is a populist argument that government is dominated, corrupted even, by the powerful interests that stand against the values of the people. Who then is included in that phrase, "we decide"? Obviously not asylum seekers and refugees. They are outsiders, and we will decide whether they become one of us. As the Tampa episode unfolded, asylum seekers arriving by boat were portrayed as undesirable outsiders who were not fit to be one of us. boat arrivals were wrongly associated with terrorism. For example, when asked by radio presenter Darren Hinch whether the boat arrivals might include bin Laden appointees, Defence Minister Peter Reith replied, "You've got to be able to manage people coming into your country," and went on to say, "Otherwise it can be a pipeline for terrorists to come in and use your country as a staging post for terrorist activities." Fairly unlikely, really, that someone intending to commit a terrorist act on Australian soil would try to come by boat. You will also recall the Children Overboard affair, in which asylum seekers were portrayed as people who throw their children overboard, even though this had not occurred in that instance. Irregular migration was also associated with national security. For example, in his campaign speech, Prime Minister Howard said, "National security is about a proper response to terrorism, a far-sighted, strong, well-thought-out defence policy, and an uncompromising view about the fundamental right of this country to protect its borders." The securitisation of borders is a trend that has swept the Western world. It's transformed immigration from something viewed as economically valuable or humanitarian or compassionate in nature and dealt with as a routine administrative matter into a potential threat to the nation. This could be a physical threat, as with the unjustified link to terrorism, or a threat to the values and cohesion of the nation. And this threat is dealt with by extraordinary measures. By extension, asylum seeker advocates are also not included in mainstream Australia. They're just part of the noise getting in the way of governing in the national interest. And last but not least, we may not be the same as we the peoples of the United Nations, under whose auspices the 1951 Convention was adopted, unless the Australian interpretation of the Convention is adopted. According to the Australian interpretation of the Convention around this time, and in particular Article 31 of the Convention, very few boat arrivals should be accepted by Australia because they had supposedly given up some form of protection elsewhere. Article 31 is almost as important as the prohibition on returning refugees, the obligation of non-refoulement set out in Article 33. Article 31 prohibits penalties on refugees who are in or enter a country in contravention of domestic immigration law. The drafters of the Convention acknowledged that refugees would often have little choice but to breach immigration law given their flight and the difficulty of securing valid documentation. Article 31 does contain some limiting language. To avoid penalties, the person must, among other things, have come directly and show good cause. However, the framers rejected an amendment to the draft convention, which would have limited the protection of Article 31 to a refugee unable to find asylum even temporarily in a country other than one in which his life or freedom would be threatened. In a paper on Article 31 prepared for the global consultations held during the 50th anniversary of the Refugee Convention, DIMIA, the Department of Immigration and Multicultural Affairs, acknowledged this. Nevertheless, the department stated, in view of Australia's position as an island, far from most current refugee source countries, few asylum seekers, especially those arriving unauthorised since 1999, arrive in direct flight from their country of origin. Most have engaged in secondary movement, often aided by well-organised people smuggling networks operating for financial gain. DIMIA also noted, rather optimistically, that the obligation of non-refoulement in Article 33 does not require entry as opposed to non-return, and said that through negotiating entry with other countries, it may be met anywhere in the world by those states who honour the non-refoulement obligation. While this statement is perfectly true, securing return of refugees to whence they had come was never going to work. Not only were these countries under no obligation to readmit non-nationals, but they were often not party to the Convention and/or did not have national equivalents of protection. Indeed, the insecurity for refugees and asylum seekers in such countries was documented at the time and provided an obvious reason for their departure. This is, of course, why Australia had to offer additional aid to Nauru, which was not even party to the Refugee Convention back in 2001. Similarly, Australia's extant aid program explained why Papua New Guinea was prepared to be involved. While it was hoped that those determined to be refugees would be resettled to another country, the majority, 705, were resettled in Australia, with New Zealand taking 401 and very few other countries taking any. So the majority of those determined to be refugees came to Australia, and in 2008 the Rudd government brought the first iteration of the Pacific solution to an end. That end, as we all remember, was rather short-lived. With the arrival of around 20,000 boats in 2012 and relentless sloganeering around stopping the boats by the Abbott-led opposition, the offshore detention arrangements were reinstated by the Gillard government in August 2012, and then later Prime Minister Rudd introduced so-called regional resettlement arrangements with Papua New Guinea and Nauru. In reality, resettlement to other countries was still required. Remember how small Nauru is, and it has been painfully slow. The situation for those refugees who were held in detention on Nauru or Papua New Guinea, a deprivation of liberty for which Australia retained responsibility as a matter of international law, has been described in numerous reports and inquiries, media stories and some excellent books. But for my money, the best is Behrouz Boochani's autobiography, No Friend But the Mountains. His book is a harrowing read, revealing in vivid detail the degradation and decline of those subjected to this harsh regime. For refugees transferred from offshore to the Australian mainland under the former Medevac laws, the solution was indefinite detention in hotels, with releases occurring abruptly and often with little fanfare over the last few years. The truly appalling experience of indefinite detention must surely resonate with Australians now, given our own experiences of rather shorter periods of effective home detention and/or hotel quarantine during the pandemic. Unlike the restrictions on liberty and freedom of movement during the pandemic, in many cases there appears to be no good reason for the continued detention of refugees and asylum seekers. Their detention is arbitrary and thus a violation of Article 9 of the International Covenant on Civil and Political Rights. Many other refugees have lived in constant uncertainty on temporary protection visas and indeed rolling temporary protection visas that do not allow people to sponsor their families to live with them or more generally to move on with their lives. Our own, usually less profound experiences of separation from family and inability to plan our lives during the pandemic must have given Australians some insight into the resulting torment for refugees. Australia's policy on unauthorised arrivals has been in limbo too, refusing to accept that these refugees may have nowhere else to go and need to get on with their lives. Australia has suffered a crisis of non-decision for the past 20 years. Our crisis over 20,000 odd boat arrivals in 2012 may usefully be contrasted with the European Union's decisive response to millions of Ukrainian war refugees this year. Now, the Howard government's response to Tampa did not just emerge out of nowhere. Rather, Tampa was a low point in a steep decline in Australia's treatment of asylum seekers arriving without a visa. From 1992 onwards, there's been a steady accumulation of deterrence measures used against them, beginning with mandatory detention introduced in 1992, of course, by a Labor government. Various narratives have been constructed as justifications for these policies. One has been the idea of a queue between Australia and the regions of conflict and persecution from which refugees have fled. The origins of this term are debated, but the Comprehensive Plan of Action for Indo-Chinese Refugees, with its emphasis on orderly departure from Vietnam and resettlement from countries of first asylum, may have assisted in formation of the idea. Unlike the response to Vietnamese refugees in the 70s and 80s, however, there are usually very few resettlement places available in most refugee crises, and orderly departure programs or evacuations are rarely initiated. Generally, less than 1% of the world's refugees are able to access a resettlement place. The queue is factually non-existent, and legally there is no requirement to join this factually non-existent queue. Queuing for nothing is pointless, and a queue to nowhere for refugees is dangerous, given the risk of refoulement or return to their country of origin. More recently, particularly during the Gillard era, a purportedly humanitarian rationale of breaking the people smugglers' business model and preventing deaths at sea has emerged. The problem is that through interception and detention, we have supplemented life-threatening journeys to safety with a black hole of despair and sometimes death, as documented in Bucciani's book and numerous other records. We've created the possibility of constructive or disguised refoulement, where people are forced to return to dangerous countries of origin, pressured into leaving by the appalling circumstances in which they find themselves. The interception program has been extremely risky, and the focus on interception rather than proactive search and rescue made it more likely that sinkings such as Civex could occur. Temporary protection visas have encouraged family members to get on boats, thus adding to dangerous journeys. And the Australian approach, whether supported by a populist or paternalist narrative, has migrated. One only has to look at Italy, while Berlusconi and Salvini were in charge, and the UK's Rwanda proposal to see this. This contagious effect means that those countries with the means to do so push the responsibility for refugees onto less able countries who will struggle to meet the needs of refugees and their own citizens. It is untenable to argue that 20,000 boat arrivals could not be accommodated in Australia, or that this posed a risk to Australian citizens. Why should this responsibility be passed to other countries? There have also been detrimental impacts on Australian democracy and the rule of law. Playing on people's fears, whether of cultural difference or competition for jobs, provides an excuse for government not to take action on the sorts of things that make us fearful, be it unemployment, wage stagnation, or climate change. And rational discussion about boat arrivals has become almost impossible. Let's think about the discussion around the inquiry into the publicisation of a boat arrival on election day. An inquiry is merited, but the fact that secrecy about on-water or operational matters was ever thought appropriate and has been maintained for so long should be extremely concerning in a liberal democracy. I think the public needs to know how Australia has complied with its international obligations and ensured the people on board were safe. Apparently they were flown back rather than being subject to a towback. We're told there's been a thorough screening of the passengers. Where did this take place? On board or on Christmas Island? With legal assistance and interpreters? Finally, what are the appeal avenues, and is there a role for the courts here? The framing of even one or two boat arrivals as a national emergency has meant that the courts are seen as a problem for swift executive action, rather than an important safeguard for the rights of the persons on board and ultimately the rule of law and our liberal democracy. Sadly, it appears that the special interest groups of elite tennis players get a better hearing than people seeking our protection. I understand why it's thought to be political suicide to suggest that the policy of turning back boats should be abandoned. We all saw how the opposition used boat arrivals to its advantage during the Rudd-Gillard government, and we all know that the opposition will use their arrival in exactly the same way today. But I think it's important to question the populist impetus to close borders and think about what mainstream values really are. Let's stop talking about the right and wrong way to come in and focus on our own processes, the stuff we really do control. There is a right way to return people who do not need protection, and that involves a fair hearing with avenues of appeal so as to guard against mistakes. It is wrong to put people in a black hole of detention as a deterrent to others. We should remember that the grant of asylum avoids complicity in the harms that could occur if people are returned to a place of danger, and that treating them with dignity and allowing them to make a contribution to our country, as so many refugees have done, is to our advantage. We also need to remember that the signal we send when we don't respect the right to seek asylum in our country is that other countries shouldn't either. If that took hold, no refugee would ever find safety. So I leave my audience today with a question. Is that really the Australian fair go?